So today we're going to be focusing on grievances. Never the most pleasant of conversations, but it does lead on quite nicely from the last one we did, which was on having difficult conversations. So I think Bethany said we're going to do about 30 minutes. We'll be going through the slides, and then please feel free to ask any questions at the end. More than happy to go through those with you. So in terms of grievance, what we always say is it's always best to follow best practice. So, a grievance can be anything in regards to a concern or an issue raised to you by an employee. It could even be something that you've noticed, and actually we'll get into that later on about how things can be dealt with informally or formally. But as we always say, first instance, it is best practice. It's resolving issues or concerns at the earliest possible point and focusing on improvement. Mohit said there quite rightly that obviously when people think, oh, grievance, they automatically think, I want that person out of my business. They're a bit of a problem, but that's not the case. This is all about taking on feedback from people and obviously resolving any concerns that are sort of bubbling up underneath the surface. Because generally when you're getting to a stage of a grievance, that's at a point where it's been bubbling around for a long time. And, we've had those conversations. It could be anything in terms of somebody's not very happy with management, somebody's not very happy with a certain practice at the business. So it really is about improvement. So it's not taking things personally when we receive grievances, but we do need to ensure that there is a process in place. So it's all about acting reasonably. So we'll get into the actual process of what that looks like with a grievance. But when generally things get to a point where we're looking at tribunals, we hope we never get to that stage. A tribunal will always apply the reasonable employer test. So that is essentially an objective assessment by a tribunal court as to whether you as an employer have acted reasonably in doing that grievance, dismissing somebody. So that's why we need to follow best practice. We put here at the bottom, obviously, a bit about ACAS. So when we're making any decision or we're following any sort of reasonable process, as a minimum, we should be following the ACAS code of practice. So that can be found online. And I strongly, strongly, strongly recommend after this having a little look at what that is. So that's about how, you're meant to follow a grievance policy and procedure. If you don't have one in place, I do recommend looking into implementing a grievance and disciplinary policy. So the ACAS code of practice, it sets out the minimum standards of fairness that workplaces should follow. So they are used by employment tribunals, as a judgment of whether you have been a reasonable employer. If we haven't followed the ACAS code of practice as a minimum, then if this case does go to a tribunal, say you've got a grievance from an employee, we've gone through the internal process, but actually we've not followed the ACAS code of practice. If it then gets to a tribunal, any award could have an additional 25% added on to that because we haven't followed a fair process. So it's really important that we are acting, consistent, we're being fair in any decisions we're making, and we're also being very transparent. And that's where this whole grievance policy, having one of those in place is really good, making sure we're acting the same for all employees. And definitely after this, happy to answer any questions, but this could be something where a bit of additional learning, I really do strongly recommend having a look at that ACAS code of practice and particularly what that looks like in terms of for a grievance policy. Okay, so discrimination. So I think on some of the calls we've obviously been through different discrimination. So on the slide at the moment, these are the 9 different protected characteristics. So whenever someone's raising concerns, we're seeing quite a lot of a theme at the moment, obviously a bit about health, mental health, which we'll get onto. But, there are all of these different things can come up, and whether people feel like they're being discriminated against, it's generally based on one of these 9. And these are in the Equality Act. So this is something that actually we do need to be very wary of, especially if people are raising a concern based on one of these 9 factors. So any sort of discrimination can be direct. So that's if someone is treated differently or worse than somebody else for a very certain reason, generally linked to one of these 9 things. Indirect discriminations, that's when we create a rule or a policy, going back to the whole grievance policy, which places some people at a detriment because of those 9 characteristics that they may have, or one of them. Associative discrimination. So that's if you know somebody with a protected characteristic. So for example, if you've got a relative who has cancer and you're treated differently because of that, that could be seen as associative discrimination. Perceptive discriminations, that's when someone believes or you believe someone has a protected characteristic. They haven't informed you of that, but you're treating them as if they do. And then obviously we go on to harassment by a third party and victimisation. So in terms of harassment, we have seen a big theme at the moment in our work on there has been a real increase in sexual harassment cases and cases that are actually going to tribunal because employers haven't been dealing with them as they should. They've not been following a process and they tend to act differently for different people. So obviously for female colleagues coming towards them, we've seen quite a few where because they don't think their employer is actually treating them the same as their male colleagues, they've almost bypassed the whole grievance process and gone straight to tribunal. And as you can see, gender, that is a protected characteristic. So what we need to do is just make sure that when we are aware of any of these issues, I mean, this is a pretty extensive list and anything other than that you probably aren't going to see as much, but you know, if someone's raising an issue that is linked to anything on this screen, if they're saying any of these sort of trigger words, it should automatically light bulb, we need to deal with this. Even if it's not on there, you know, there are other issues which you're bound to see, but as a, you know, as an employer, this is the sort of things when we hear, we need to act. So another one which we are seeing a big theme of at the moment is mental health. So in terms of grievances, okay, so you might get some on discrimination, but a big one we're getting is people not dealing with mental health concerns when they're made aware of them. So most common types we're seeing are stress, depression and anxiety. Stress, we are seeing a lot more doctors' fit notes for work-related stress. People have been signed off because of additional workload, feeling they're not getting support, and that's having an impact on their stress. Depression and anxiety, I'm sure you're all aware of these. And it is one of those where we are seeing a big theme and they are considered protected characteristics, or may be considered, I should say, that's up for a tribunal to decide. But it's all about what communication and support we can offer employees in the first instance. So before we get to a grievance process, what are we aware of with that certain employee? Have they raised concern to us previously? Have we tried to support them? Have we had those difficult conversations we've spoken about where we've actually put in provisions in place or made reasonable adjustments? So it's all about, you know, when performance and conduct concerns link with mental health concerns, how are we dealing with that? How are we supporting our employees to avoid then a grievance coming in saying that we're not supporting, they have this medical concern and we've basically completely bypassed it. So that's why we put this on here, these slides about mental health and discrimination grievances, because generally these are what we're seeing links to. This is what we recommend as to avoid that grievance, is to deal with it as soon as possible. We haven't put the slide on here, but we usually use one which says nip it in the bud. If you're seeing something, say something. If you're hearing things, people tend to get so-and-so said so-and-so is feeling a bit, you know, stressed at work. Let's listen to those conversations. Let's keep our ears to the ground. Let's reach out to employees who actually are acting a little bit differently, maybe at work, and actually try and really help people in the best way before it gets to a grievance. So I'm hoping many of you haven't had grievances before. If you have, generally it's not the most pleasant thing to get through, because essentially you normally get either someone coming to you saying all of their concerns, all that they feel that they've been wronged in the world, or it's a very lengthy email in which they detail every single point that they would like basically looked into. So what is a grievance process? Again, linking back ACAS code of practice. There is a set process that we need to go through that can be linked in a policy, and that is as a minimum what we should follow. If you've got a grievance policy in place, as soon as you get a grievance in, that is what you need to follow, because that is what the employee will be expecting. So it's generally followed, a grievance process, when there is a problem or a concern. So we can look at whether it needs to be dealt with formally or informally. If we are hearing someone's basically just come to you in your office, knocked on the door and says, I am feeling really stressed out, that is not necessarily a grievance at this point. That is a conversation we can have for support. If someone's come to you and says, however, I went into work and actually a sexual comment was made towards me by a male colleague, immediately I'd be thinking grievance, let's deal with this formally, because that's pretty serious. Not that the other isn't serious, but there is a bit of a judgment call that could be made of, you know, actually what can we do to support? Whereas if someone's got a problem with another employee of that nature, we're looking at safety. Well, it's a judgment call pretty much from you as to whether you think we need to investigate and look into it. And I would almost say to them, please write it down, let me know what's happened, and I'll look into that for you. And then we can follow that as a grievance process. Again, ACAS framework as a minimum. I will drill this home, I think, all day. ACAS Code of Practice. Please, please, please give it a read and make sure you're sort of a bit well versed as to what that means. So, you know, as we've said here, we're following our policies. We recommend downloading a policy. I'm not sure if that's something Compass can offer. That's definitely something HR department do, and we'll be happy to have conversations. I think, to be honest, Compass probably has their own policy, which we've helped with. So it's about, you know, making sure that we do have one of those in place. And then at the end of a grievance process, everybody has a right of appeal. So there's almost 2 hearings with 1 concern. So I'm just checking the time because I know I'm talking quite a lot. So we'll move on to the next one, which is looking at grievance dues. So when you receive a grievance and you get an email with 5 points on saying, this is what's happened to me, X, Y, Z, this is why I'm unhappy, the first thing we need to do is invite that person to a meeting. I recommend doing this by letter. You can attach a letter to the email. Generally, you want to hold it within 5 days. So if we could do a recorded delivery on a letter, email, send it back, acknowledging that you have heard their query or you're going to be listening to it. So that's just making sure that we're obviously first step. Within the letter, you can detail that that person has the right to a companion. Now, a companion can either be a work colleague or it can be a trade union member. Now, generally, you wouldn't need to offer anybody else to be accompanied. However, somebody, and we've had this recently, they come to us and say, please can my mum join, please can my dad join. At the end of the day, as long as that companion is aware of what they can and can't do, they can't speak on behalf of the individual, but they can be there as support. Our judgment is actually, what would a tribunal say if you've refused somebody to bring their mum along? If their mum's not going to talk and is just there for support, it's nothing against the company, and I think it would look worse actually if you don't approve that companion being part of the meeting. So I personally would let them join, but I'd be very clear as to what their role is. You would need to arrange a note taker. So for a grievance, you have 1 person hearing the grievance. Generally, that's who the emails come to. Then you need to appoint somebody else to take notes. Now that I'd recommend a more senior manager, but it's obviously somebody who's able to maintain confidentiality. They don't really have a role other than taking notes during this process. They're not allowed to voice opinions during the meeting, especially if there's a bit of an argument at work. They can't jump in saying, actually, you didn't say that, you didn't do that. Their role is to be impartial, is to just take notes and to record an accurate representation of the meeting. Doesn't have to be verbatim, however, close enough that it is. You don't have to put gasp and, you know, murmur or whisper. It's more just getting an essence of what was said at that meeting, so that when you come away and you're looking at those notes, we get a rough understanding of what's happened. So we say here, consider precedent. So we need to make sure that when we're following the grievance process, it's the same for everyone. There's no special treatment. So that's why, you know, inviting people, the time limits, allowing companions. If we're allowing someone to bring their mum, then if the next person wants to bring their mum, we should allow them to. There shouldn't be any difference between how we follow a process. And then we put here, maintain confidentiality. A lot of grievances tend to be very personal and very private, and that is how we want to keep it. You don't want it spreading as wildfire throughout the business. We've had that quite a lot with, we've had one client where a grievance was raised against a manager, and every single person I'm not even joking, got involved. There was about 10 or 11 meetings held with each individual person, and it was very apparent that people were talking because stories were changing, stories were becoming very, very similar, and you can tell. So it's always really important that you are maintaining confidentiality and asking people to remain confidential when they're dealing with it. I'll go on to my next slide. So during the hearing, you always ask how the employee would like the issue resolved. So by that, you've gone through each point that that person has raised as a concern. You've dug into each question. You've asked, we'll use the example of an argument at work. You've asked who the argument's with, who was witnessing it, how did that make them feel, what impact has it had on their day-to-day role. Someone might have said that actually it's impacted their mental health. How has it impacted your mental health? What has been done, or what support have you had in the meantime? Have you had any time off work? It's asking all those questions. We're drilling down, digging, and we're basically finding the facts, because every single person who they raise as witnessed, we're going to go and meet with them as well and get their account of the situation. We use a very nice phrase saying naff off, which is never assume, find out facts first. The grievance hearing is a time to find out facts. We're not making snap decisions. We are listening. We are taking on, it's not even it won't be a 15-minute meeting. It's probably going to be an hour long. We're going to ask the questions we need to know so we can go away with as much information to be able to really investigate into that person's concerns. So like I said, at the end, we'd ask the employee how they'd like it resolved. If it's an argument, they might say, actually, I just like mediation. You get some who are a bit dramatic and say, I would like that person fired, which obviously we're not going to be able to confirm. But, we definitely could say, they might say, actually, I just want that person to be aware of the impact that those comments have had on me. So asking the employee how they like it resolved helps you to be able to understand sort of what level we're dealing with here, and also what's likely to get the best outcome or results for everybody. We put here adjourn for further investigation if needed. So like I said, if it's an argument, we're going to make sure that we go and speak to every single person who witnessed it. We're going to ask people for summaries. We're going to clarify points. If an investigation someone's asked or said one thing, we're going to check that with another person. If they say something different, we can always re-meet with that initial person. So it's really for you as an investigation officer getting an understanding of the full situation. The person who's taking notes would take notes for each individual meeting, so they are also, able to see the background. Again, they're there in a sort of a confidential capacity and to take notes, but sometimes it is quite handy to have someone to talk to, especially when it gets quite difficult. With this 10 or 11 grievance meeting we had, personally, that was quite difficult. It was difficult to get an understanding of what was the fact, what was fiction, but what we always say is that you are dealing with, when you see facts, when you see screenshots of messages, it's really important to ask people for evidence. If they said, oh, so-and-so sent me a message, I've got an email from them, please can you provide me with a copy of that email? You can ask for evidence to help support someone's concern. Or if it's the other vice versa, the person who a grievance has been raised against, we can go to them and say, you've been accused of sending so-and-so an email. They might say, I've never sent that. This is the email that I sent. And we can ask for evidence from either side. Call records. You can ask for a picture of someone's call records to help you summarise that case with as much fact as you can. Main thing before you go into these grievance meetings is to really, really try and avoid prejudging. I am terrible for this. I hear a grievance and I think, that is terrible. What has that person done? I can't believe they've done that. And actually you go into the grievance and you might hear a completely different story from each of the meetings. So it's about being really impartial and just dealing with what's in front of you rather than knowing the backstory necessarily. So that's why it's important that it is confidential, that you are looking at it really objectively and you're treating everyone the same, so that there isn't any favoritism, because that's something which you personally, if you were raising a grievance, you wouldn't want that. So that's why we need to just be really careful in those processes. So we've held all the meetings. Now what? You've got an idea of this argument. You know roughly what's been said, what's been done. Now what I would do is you need to write everything out in an outcome letter. This letter, you would almost go through all of the points that was raised in the initial grievance. When I write them, I tend to have the printed out grievance on one side, all the meeting notes that I've taken on the other, and you're building this case, you're putting it all together, we're tying it up. So it's basically setting out exactly what you've done. So you've met with X, Y, and Z to understand what happened on this date, and you're really setting out the case. It's almost a little bit like you've got doing a crime report, putting dates and times. When did meetings happen? Who have I met with? What did they say? And then you're pulling it together. You raised this point to pass through your grievance. I believe this point is upheld because of XYZ. You might then have another point which you believe is not upheld. So in a grievance, you can have points that are upheld or not upheld. And in that case, you would say the whole grievance has been upheld in full, upheld partially, but it doesn't necessarily have to be clear yes or no decision, essentially. So more than happy to go through if people have got questions on that, because I know this part can be a little bit difficult to understand. But essentially, if you've got 5 points of a grievance, you might find that you've got the facts to cover 3, but actually 2 of them you can't see how they're true or not. So you could uphold 3 parts of that grievance, not uphold 2. So you tell that person your grievance is partially upheld or upheld in part. And then what you would basically do in that letter is essentially say what you believe would be the outcome of this, or what you're proposing. If it's an argument, you might say mediation. I believe mediation training would be beneficial here. We'd be happy to facilitate that, and you might put the name of an external provider or a impartial manager. Another version could be, we are going to hold or follow our own internal policy and procedure in regards to discussing with this employee. What you can't do is necessarily say, I'm going to fire that person because of what you've said. There's a bit of confidentiality, there's private information, we're looking at GDPR, all of that sort of data protection. We can't necessarily expressly state what we're going to do, but we can say we're going to follow our own internal procedures in making sure that person is aware of the impact that they've had and that never happens again. So we can say what we're going to do without being explicit. Now, at the bottom of this, once you've summarised, you've put together all of your hard work, you've essentially written a crime case that you believe is completely watertight, you still have to offer that person the right of appeal. Generally, this would be with a different manager. So the right of appeal can't come to the person who's held the grievance. It's got to be a different person. And essentially, it's for them to go back and say, I disagree with everything that you said. And it is heartbreaking when that happens, especially when you put in a lot of hard work and you think, actually, it's clear cut. I've done all the evidence. I know the answer to this. And they come back and say, I think you're wrong. But they have that right. So then we need to find somebody else to run a completely different appeal. Now, an appeal isn't necessarily rehearing the whole rest of the grievance, but it's appealing points within your grievance outcome, which then a new person would investigate and look into. Same situation, different note taker, different chair, and then that person running the appeal will then assess what they believe needs to be done, whether the process has been followed correctly. Is there any additional evidence? Are there further screenshots of messages that have come up recently? This is what the appeal process is all about. Again, we say it's within 5 working days of getting an appeal. We need to get back to it with a letter. Same process, but you're just rehearing parts that have been raised in that appeal, not the whole grievance process completely. Hopefully that makes sense. In smaller organizations, you may want to consider, so for example, an owner or a very senior manager, you might not want them to initially hold the grievance because you'd almost want to keep them for an appeal. So it's just about looking at, in terms of who do you have in your company, who can run different processes, and essentially who can do what. Again, we need to keep a record of all the notes. The original grievance can be shared with that impartial person, but again, it's a fair approach and another outcome would need to be written. However, there is no further right of appeal. Once your appeal has been done, that person or the employee, if they still have concerns, they have unfortunately exhausted all internal processes. So there is no further right of appeal. Once you've done a grievance and an appeal meeting, then eventually, sadly, it would have to go to ACAS, and either you would be able to reconcile via a settlement, or it potentially would go to a employment tribunal, and initially a tribunal hearing who would listen to see if they had a case, which is always very frustrating, but we have seen quite a few. At the moment, ACAS are extremely busy, however, so that I think there's like almost a 2-year tribunal wait period. So ideally, we hope and get people, once you've done the appeal, you hope people are happy because actually you've done a full process, you've investigated correctly, we hope, and they shouldn't really have further questions. If they do, obviously we hope that actually if it did go to a tribunal or went to ACAS, we've got a pretty good case to say this is what we've done, we've followed the ACAS code of practice as a minimum, but this is how we've gone above and beyond for that employee. So that is generally, in a nutshell, grievances and the grievance process.